Hello everyone. In this video we are going to say about Indian Evidence Act 1872. So first we will understand the term what is meant by evidence. The evidence word is derived from the Latin word evidere, which means to show clearly, to make plainly certain, to ascertain or to prove. So the act is applicable to both civil and criminal cases. The act is divided into 11 chapters and 167 sections. So basically the evidence law plays a significant role in trial. It may be civil or criminal. So first we will understand how the criminal proceeding will take place. First they will file an FIR, then after the filing the FIR, the investigation will proceed. After completion of the investigation, they will file the charge sheet, then magistrate will take the cognizance of offence, then they will issue the summons, then they will frame the charges, then the judge will ask for the plea of guilty. If the accused denies, then trial proceeds. After the trial, the oral argument will begins. Then at last, judgment will be pronounced in the court. See, here the evidence will be collected during the stage of investigation. Then it will be brought before the court during the trial process. So where the evidence plays a vital role means, see, the judge who was sitting in the court, he doesn't know what happens. So here we are going to recreate the facts during the trial process. So the main purpose of trial is to prove or disapprove the fact. So what evidence we are going to place before the court is, it may be direct evidence or the circumstantial evidence. Next, we will see the overview of the Indian Evidence Act 1872. Here, the act is basically based on three questions. First is what to prove. Second is how to prove. Third is who is to prove. So first we'll understand the first question, what to prove. See, basically what you are going to prove in front of the court is fact in issue or relevant fact. Only these two things you are going to prove. This provision has been dealt under section 5 of the act, which says evidence may be given in any suit or proceeding. Here the suit means civil suit, proceeding means criminal proceeding, of existence of or non-existence of every fact in issue or such fact are herein declared to be relevant and no others. So here basically we are going to prove we are going to give the evidence only for fact in issue or relevant fact. So further the relevant fact are dealt under section 6 to 55, we will study in detail later. Then how to prove. See, how you are going to prove in front of the court. There are two things. Only you can prove via oral evidence or documentary evidence. Oral evidence provisions are dealt under section 59 and 60. So who will give the oral evidence? The witnesses. So who are competent witnesses to give the oral evidence? Section 118 to 120 deal with that. Then how many witnesses you can place before the court? You can place whether 100 witnesses or even one witness is sufficient. There is no such limitations. You can place n number of witnesses or even one witness is also enough. That was provided under section 134. Then here the examination will take place. If the oral evidence has been placed, the examination will take place. That provisions are dealt under section 135 to 165. First, examination in chief. Examination in chief means who is the complainant. If in criminal case, the complainant will be the examination in chief. Then in civil proceedings, the plaintiff who has filed the suit, he is known as examination in chief. We are going to examine that person. Then cross-examination. Here the defense counsel will do the cross-examination. Then re-examination also will take place. Then comes documentary evidence. There are two kinds of documentary evidence. One is primary evidence, then secondary evidence. Primary evidence means original document you are going to produce before the court. That was dealt under section 62 of the act. Then secondary evidence means duplicate copies. Then there is also one cardinal principles are there, which is dealt under chapter 6, the exclusion of the documentary evidence, the exclusion of oral evidence by the documentary evidence. Here if there was the conflict between the oral evidence and documentary evidence, the documentary evidence prevail over that. Then who is to prove? Here upon whom the burden of proof lies. That was the provisions are dealt under section 102 to 111. For example, if the murder take place, the prosecution side have to prove he has done XYZ, namely they have done the murder. They have to prove, prosecution have the burden of proof. Suppose if the accused denies that during the, for example, if the murder take place in Chennai, then accused was saying no, in that time I was in Delhi. So here accused has to prove that. So that provisions are dealt under section 102 to 111. Then apart from this, there are two things we have to understand. First one is, though fact may be relevant but need not to be proved. There are two circumstances. One is judicial notice. The provisions are dealt under section 56 and 57. Judicial notice means basically these are common facts, like everyone knows that. For example, how many states are in India? 29 states. Everyone knows that. So here that is known as judicial notice. Then admission. If suppose someone commits the murder, then he was admitting that I have done the murder. So we are not going to prove that, why ask him to prove that why how you did the murder. So that provision, admission, is dealt under section 58. So basically these two things need not to be proved, because for the better convenience of the court and not to waste the court time. Then comes relevant but shall not be proved. Here, even though fact is may be relevant but shall not be proved, there are circumstances. For example, confession to the police officer. This is provided under section 25. If you are giving the confession to the police officer, like we can't prove in the court of law. Then confession in police custody, section 26. Here also we are not going to, this cannot be proved, because in the matter of public policy, so we are not allowing these circumstances to prove in front of the court. Then privilege communication. The communication between husband and wife, section 112. Even though the fact may be relevant, it shall not be proved. Then attorney-client privilege, section 126 provides that. Then official communication. Official communication means the state of affairs. Suppose the military defense minister is ordering something to the officers or soldiers to shoot or to attack something. So these things we cannot prove in court of law. So these are the things relating to the introduction to the Indian Evidence Act. So that's all for today's video. Thank you.